Well, thank you very much. First of all, I should start by noting that we're, as you have observed, probably a little bit behind time. So we're going to have, our goal here is to have approximately 45-minute session, about 30 minutes of which will be question and answer and discussion among our panel of two here, and then we'll open it up to questions. So just to calibrate you, that will be a little bit delayed, but not too much. So let me just start by, well, first of all, re-welcoming President Janet Napolitano to the stage. We already had the introduction, so I won't read the whole thing again, but just will say that she leads an incredible enterprise with something like 500,000 current faculty and students and staff. It's just just an incredible place, so thank you very much, President Napolitano, for joining us here. And then to our left, your right, is Eric Dreiband, who currently serves as the Assistant Attorney General for Civil Rights in the Civil Rights Division of the Department of Justice. Before arriving at the Justice Department, AAG Dreiband was a partner in the Washington, D.C. office of the law firm Jones Day. Previously, he served as the General Counsel for the U.S. Equal Employment Opportunity Commission, where he directed the federal government's litigation of Title VII of the Civil Rights Act of 1964. He's also had several other government positions. He has a JD from Northwestern University School of Law, a MTS from Harvard Divinity School, and an AB from Princeton University. So let's welcome AAG Dreiband and President Napolitano. So in general, I'm going to try to ask these questions to both of you. There'll be one or two, perhaps, that will be directed to a particular person because of your affiliation. But I'll start out with a high-level one. How would you characterize the state of free speech on college campuses today, and what kinds of things are you concerned about, and what kinds of things are you most hopeful about? Does this for either? President Napolitano.
So I'll start. So I think from a policy perspective, free speech on our nation's colleges and universities is widely respected and upheld, and it's there. It's particularly there, I would say, at the University of California. I think the more difficult question is, how is it in practice? And there, I think we do have some underlying questions and issues that need thought. Free expression and freedom of speech versus speech that specifically targets particular individuals or groups. Protection of free speech versus the cost of providing security for controversial speakers. How to promote and educate the next generation in the values of free speech and the values embodied in civil discourse, and at the same time make sure that you are not just speaking but listening to all voices. So I think from a de jure perspective, we're very, very solid, but there are some underlying implementation or practice questions that need to be addressed.
First of all, let me say thank you here at the University of California and President Napolitano for inviting me to speak today and join the panel. It's a real honor, President Napolitano, to join you and Professor Villasenor, too. I agree with much of what President Napolitano said. I look at it slightly differently from the standpoint of the Justice Department and what we've seen over the past few years. And I would say, from my point of view, in terms in practice, as President Napolitano said, and I think I agree, I think that free speech on campuses today, I think, is under threat. There was a very interesting study done by a certain professor from UCLA, Professor Villasenor, that suggested that amongst college students today, there is a significant lack of understanding about the First Amendment's freedom of speech protections. And so, for example, what his study found, and he's here so he can speak to it if I mischaracterize it, but what he found was that a majority of students would prefer that colleges create a positive learning environment by prohibiting speech that they find offensive or biased. That a majority believe that it's appropriate to shout down speakers with whom they disagree to keep them from speaking. That a majority believe, mistakenly, that the First Amendment requires speakers to provide an opposing point of view, and that a significant number, a minority, but a significant number, 19% overall and 30% of men, believe that it is appropriate to engage in violence to prevent speakers from speaking if they disagree with them. Those data and those findings are consistent anecdotally with what we've seen at the Justice Department through litigation in which we've participated. We've seen campus speech codes that we have determined are vague, overbroad, that chill speech, that engage in prior restraint on speech. We've seen colleges and universities engage in viewpoint discrimination. And we've seen colleges create free speech zones limited to minuscule areas of campuses. Having said that, though, there's a lot to be thankful for on college campuses, and each college, of course, and university are different and unique, and many of them do encourage free speech and free expression. But we do have concerns at the Justice Department that freedom of speech is, in certain instances, under threat, and that college students may not fully understand the First Amendment and the values embodied in the free speech protections of the First Amendment.
Okay, thank you very much. Next question, I guess I'll reference this incident at Berkeley a few weeks ago where a member, somebody who was representing a conservative organization, was physically assaulted by somebody else, and as was correctly stated earlier, the person who was assaulted was not an affiliate of UC Berkeley or the UC system, and the person who is accused of having committed that act is also not somebody who has a current formal affiliation with the UC system, as far as I'm aware. So I guess the question is, what can be done? Can be done to sort of hopefully minimize the probability that such incidents repeat in the future, and also from a legal perspective, what can colleges do, given the fact that by definition they're open environments and so on. So any reactions to that?
Yeah. So I think first of all, the victim was provided space at the Berkeley campus. He was attacked. The university leadership promptly spoke out against the attack. The university police promptly did an investigation, identified the attacker, effected an arrest. Charges have been filed. It is, I must say, difficult for me to see what other actions the campus could have taken in this circumstance. They provided open space. The open space was subject to a violent act. The attacker was charged as being prosecuted. The campus leadership spoke out and said this is not consistent with university values. So I must say it is frustrating to have that incident. Of the thousands and thousands and thousands of things that happen on college campuses every day, singled out as an example of how a university is not allegedly for free speech.
If I just add just a small point. I don't want to address the particular incident. I don't know the facts, and certainly defer to President Napolitano's description of them and the response by the university, which, as President Napolitano described, strikes me as appropriate and reasonable. I think that, and more than that, I think, and very sound. So, but I also think, and I agree, that it's important not to draw large generalities from single incidents. When we think about campus free speech issues, anecdotes and individual circumstances are important for informing how we think about them. But I also think that the larger trends through, if we have them, if we have data about what we see at a broader level, can often inform how we think about what's happening. So I agree with President Napolitano that a single instance like that cannot and should not provide the basis for generalizing broadly either about the University of California or higher education in general. Having said that, though, of course, an attack like that I view as more of a criminal matter as described. Again, I'm not offering an opinion about the particular case, but when someone is attacked, it's a terrible thing like that. If they're physically attacked or violently attacked, obviously that is a matter for criminal prosecutors to deal with and in appropriate circumstances to bring charges. Having said that, though, I come back to Professor Villasenor's finding that 30% in his study of male college students think it is appropriate and to engage in violence to stop speakers with whom they disagree. And that's not a majority, and the overall number is 19% in his study. Women were a much smaller percentage than men in the study. But 30% of male college students believing that it's okay to engage in violence suggests to me that there is a serious misunderstanding among our college students about the value placed in the First Amendment and freedom of speech protections, and that can lead to incidents of violence, individual incidents of violence of the sort that Professor Villasenor described.
Thank you. This next question would be for AAG Dreiband. The Justice Department has become involved in the sense of filing a statement of interest, I believe is the correct term, in several free expression cases at various universities, including the ones, several that you may be familiar with. I guess one thing that might be helpful for the audience is, first of all, to briefly explain what a statement of interest is, and secondly, more broadly, how does the Department of Justice decide when to get formally involved by stepping into a legal case through filing a statement of interest?
Okay. A statement of interest is something that the Justice Department has authority under a congressionally enacted statute to file in any court proceeding when we determine at the Justice Department that it would help the court determine a legal issue or a case that is pending before court, and we think that the government has an interest in the issues in the case and an appropriate and proper outcome of the particular matter in a case. Similar in some ways to a friend of the court brief that private institutions or individuals might file in a particular case. But really, we determine they're appropriate only in certain circumstances when the government itself, we think, has a particular interest in the case. With respect to the First Amendment, the government has, in my view, an interest in the proper enforcement of the First Amendment, the protections embodied in the First Amendment. However, the Justice Department does not have any statutory authority to enforce the First Amendment. Rather, we have an interest in the First Amendment protections. And those go right to the core of the oath of office that I took when I joined the Justice Department, which is an oath that includes me swearing to protect and defend the Constitution of the United States. And so when we see allegations and evidence in a particular matter of alleged violations of the First Amendment, we will analyze the record that we have before us, and we will make a determination about whether it is appropriate for the government to seek to vindicate, in this case, freedom of speech protections embodied in the First Amendment. We do not file statements of interest in any case in which someone just simply alleges a First Amendment violation. For example, we don't immediately run into court after someone files a complaint in court, but rather we wait until there is a sufficient record, usually at least at what we call a dispositive motion stage, after there has been discovery in the case, sworn testimony, things of that nature, and that something is pending before court and we deem it appropriate with a sufficient record that we can evaluate the issues in the case, and then we will, if in appropriate cases, use our judgment to advise a federal court, usually, or it could be a state court, but usually a federal court, that a particular standard should govern the court's consideration of the case, given the evidence that we have before us and the evidence that we understand is before the court.
Okay, thank you very much. One other question, which I'll sort of key off of we had some comments earlier today about the costs of providing security and controversial speakers. And so just to frame it, I think most people would agree that it's really concerning if you have universities spending many, many millions of dollars, which could otherwise go to student scholarships and hiring more instructors and things like that. On the other hand, if you then put, if you essentially put a number and say, well, we're not going to spend more than X dollars, to provide security, then you, in some sense, almost incentivize people who want to disrupt an event to sort of create enough of a perceived threat that the university then makes the decision that they're not going to do it. So how do we, on the one hand, protect the dollars, which really are there for the student's education first and foremost, but at the same time not allow what amounts to a roadmap to veto speech, if we sort of use cost as a threshold. And again, I'm not arguing we should spend millions of dollars. I'm just saying, how do you sort of juggle that tension? Any thoughts from either of you on that? Because that is a front, and came up before. That question is implicitly or explicitly going to be front and center in the coming years.
Well, I think Chancellor Christ at Berkeley, said it well. So freedom of speech is not free, and I think to the extent it can reasonably do so, it is for the university to provide security for any broad spectrum of speakers. Now, what is reasonable? That's the gray area. I don't think you can just set a dollar amount. I think there's lots of First Amendment issues if you just say, well, our budget for security is X, and if it's X plus 1, the event will not occur. And because I think, John, to your point, it permits of gaming the system and the like. But this is, to my knowledge, Eric, you may know otherwise, I don't think that precise issue has ever been litigated in court. Like, what is the financial obligation? And at some point, is the university's, if a university were to disinvite a speaker because of the cost of providing security, at what point is there a violation there?
Yeah, I agree, President Napolitano. This is not a well-developed area of First Amendment law. And I worry that it's going to become a well-developed area of law. Universities are not bottomless pits of money. They have budgets. Public universities are taxpayer funded. They have competing demands on their use of limited resources. And the same is true of law enforcement. Local police departments can become involved in trying to keep the peace, particularly at colleges and universities that are kind of located in urban settings where events may happen, intermingled with the local community, for example. So it's a dilemma, I think, for local law enforcement as well as for universities and colleges when they're faced with, really what amounts to threats of violence related to campus speakers, let's say. I think what we have seen, at least at the Justice Department, are instances where certain institutions imposed in advance of an anticipated speaker what the sponsors of the speakers regarded as prohibitive costs, and then that has been litigated to a very limited extent, where the plaintiffs would claim that they were prevented from sponsoring what most would regard as a potentially controversial speaker on a college campus because the college or university demanded an upfront payment, either an entire or partial reimbursement for an anticipated security-related cost. But I think it's too early to tell where, for example, the federal courts are going to go on that. I think from our standpoint at the Justice Department, I sympathize with President Napolitano and others in higher education, and I do think that at this point, given the undeveloped nature of these issues, that a rule of reason will govern, and on a case-by-case basis. I do agree with President Napolitano that setting some kind of arbitrary limit is likely to be, I think, I would predict, stricken down by the courts. But on the other hand, universities and colleges do have limited resources, and they have to balance that with their own commitment to free speech. And for public institutions, their commitments under the First Amendment. It's a difficult issue, and it's one I think we'll see a lot of litigation on.
Thank you very much.
Maybe it's an issue that one of the fellows at the center will
Can
dive
solve?
into. Yeah.
We can have that solved by next year's conference, right? I'm going to ask one more question and then open it up to audience questions, because I always think the audience, I'm sure the audience has better questions than I do, and so I want to get to those so you can think of some questions. But the last question I'll have is one of the ways that we can sort of frame the debate, or I don't want to say the debate, but the challenge, is that there is in some sense a tension, in the sense that if we're talking about something innocuous like the weather, then we can have different viewpoints and no one's going to really get too upset about that. But there's any number of third rail topics, and we all know what they are, where sometimes the very expression of certain views on those topics is deemed to be essentially an attack, and to be hurtful, and to be something from which people should be protected. And so I guess my question is, how do we balance? On the one hand, you have some who would argue that they should be protected from hearing these views that are literally viewed by them as an attack, in some sense akin to almost a physical attack. Yet on the other hand, people who want to express those views feeling that they shouldn't be essentially shut down on the grounds that somebody says that the mere expression of that view is an attack, and therefore you shouldn't be able to make it. So, how can colleges navigate that tension between wanting to protect students within reasonable limits, and wanting to foster free expression, free exchange?
Well, I'll start first then. The First Amendment contains very narrow exceptions for threats of violence, statements that create a hostile environment, that a severe and pervasive type atmosphere where somebody is being harassed or some group of people are. On the other hand, but those are very narrow. And I think it's important to remember kind of the free speech movement in this country and its relationship in particular to the civil rights movement as a point of reference. During the civil rights movement, we saw freedom of speech led by people like Martin Luther King Jr., by people at the University of California, Berkeley, for example, who were saying things that a lot of people didn't want to hear. These were people, and in addition to Dr. King, but there were other civil rights supporters, members of the civil rights movement, including students who were protesting the Vietnam War or various civil rights violations from their point of view, and there was violence and things like that. People didn't want to hear these things. But yet, by having and protecting the freedom of speech that we value in this country, people were able to say things that other people found offensive. Now, that's different than currently what we have. We seem to have something what I would describe as a turning of the tables on some colleges and universities in this country, where certain types of collective groupthink seem to exist, where everyone is thinking in a like-minded manner at times. And I think students feel that speakers must conform to this kind of uniformity of thought, and if they don't, that somehow this is a violation of their right to be safe on a campus. That's not in any way to justify harassment or threats of that nature, but the First Amendment is designed to protect and foster speech of those who say provocative things, like Martin Luther King Jr., for example. And I think it's important to remember that while we might disagree with someone in terms of their point of view, that we can always learn from them, even if we disagree. And if we don't permit broad protections for freedom of speech on colleges' campuses, I think what we will see, and may already be seeing, is self-censorship from students and others on these college campuses and elsewhere who may be thinking, well, they might agree with the controversial speaker, but they don't want to engage in speech with their peers on the campus because they're fearing retaliation, either from professors or faculty or their student peers. And so the notion of dialogue and learning from one another, even with whom we disagree, I think can degenerate pretty quickly in that atmosphere. Having said that, let me say on a positive note, though, there are many colleges and universities in this country that have signed on to what I would describe as the Chicago Principles, standards first that emerged out of the University of Chicago, where there's a statement of commitment to free expression, the freest expression possible, not justifying harassment or threatening type language, but committing institutions to that, and I think we've seen a growing number of that, which I think is very encouraging.
Thank you very much, President Napolitano.
So, look, I think the role of the university is to protect physical safety, but to prepare and to educate our students to be able to engage in vigorous debate, argument, discourse with people of all different persuasions, and to be able to counter, as I said this morning, speech with more speech, kind of the Louis Brandeis theory on the First Amendment. I think where it gets gray and difficult is when we say, for example, well, speech can't be harassing or hurtful. Well, our vision or your vision or my vision of what's harassing speech may be different from someone who's coming from a different place, with a different background. So how does that factor into the calculus? And I think in the end, where we end up is with the absolute need to educate about the First Amendment, free speech, its historical context, as you mentioned, and to prepare students for a society which is all engaged in all different kinds of speech coming from all different kinds of media, etc., but also to support students and student groups who themselves feel that they are particular targets of harassing or intimidating speech that is designed merely to provoke and not to put forward any kind of thoughtful premise. And I think a good university has to be able to do both. We have to be able to protect the values inherent in free speech and in the First Amendment, and also to support students who may be the subject of particularly hurtful or venomous speech. And I think this is also an area where the center can contribute some deep work and some thoughtful work on what does that really mean.
Thank you both very much. So let's open up to some questions, and I guess preferentially from students. I see a student, I think, right here. But if anyone who wants to ask a question, please raise your hand. But students, I would like to give priority to. So.
Hi, my name is Frances James, and I'm from UC Berkeley. For Mr. Eric, I want to respectfully disagree with your comparison of Dr. King coming to UC Berkeley to discuss free speech and civil rights with the recent protests such as Milo Yiannopoulos and Ann Coulter coming to campus. I think Dr. King came to campus in 1967 at the heel of the Jim Crow era, and where black people were literally put below white people, versus I think that what's going on now is a spewing of a rhetoric that is against people of color, but that's not the point. I just disagree with that. But I would like to ask, on the terms of safety, in the sense that we spent $3.7 million when Milo Yiannopoulos came, and being a student who actually goes to Berkeley, I know, A, what that protest looked like. I stood there for the whole thing, and B, the hurdles and obstacles that I had to navigate through going to campus every day just because everything was barricaded, shut down. So when it comes to safety, when we talk about protecting students from these speakers and what's going on, how do you respond to students who feel unsafe by the safety that you've put on campus? For instance, we had hundreds of officers in riot gear with their weapons loaded just on their back, and they were hanging out on campus. We have what we call Black Wednesday every Wednesday, where Black students, all 2% of us, can congregate in front of our Golden Bear Cafe and be ourselves and listen to music and embrace our culture. However, having police officers in riot gear surrounding us inherently makes us feel unsafe. And so how, going forward, can we protect students during these big movements and having controversial speakers of either side coming to campus while still ensuring that our minority students and people who may feel triggered by that specific safety still feel safe?
Well, first of all, thank you for the question. I think you raise an excellent question. It is not a safe environment to be walking around a college campus with armed guards, as you described. And I was not addressing the particular instance you're talking about. I think it says something, though, about what happened and the way you described the facts. I mean, I'll defer to your description of them. I wasn't there, obviously. I think it's a tragedy when we have in this country circumstances in which speakers are invited to speak, admittedly provocative speakers at times, and that results in threats of violence or actual violence, number one, that threatens students' safety, the safety of the community, costs a lot of money, as you say correctly at times, and prevents speakers from speaking. And I think the way to respond to that is simply to encourage as much speech as possible. And so, for example, if a particular speaker is someone who is disagreeable to you or your peers, then sponsor a separate event to bring in someone who you think the university can benefit from hearing from. In terms of the cost, a multi-million-dollar cost to me is quite high, obviously. And I would defer to President Napolitano about her judgment about those kinds of amounts. But I think what is more disturbing is that kind of cost had to be incurred merely by inviting a speaker to a college campus. I think it is a terrible tragedy for this country and for the students affected, and I think it's something that I think we should never see or hope to see again in our country.
Yeah, and I would say there were two Milo events. There was the first one where the Antifa came from off campus and caused a lot of property damage. That's the one you were at, I think, right? The larger cost was incurred when he was having Free Speech Week at Berkeley, with a lot of publicity and chatter on social media about it, et cetera. And the campus designed the security plan for that, keeping in mind what had happened at the first Milo event. So, you know, ideally, we wouldn't have those kinds of costs in just any situation. And Berkeley, as you know, has speakers of all stripes all the time. It's like a free speech zone, and you just walk across Pearl Plaza on any given day, and you see it, and it's fine. You know, nobody really notices. But in that particular circumstance, I think the campus acted because of the fear of real physical damage or harm to students.
Thank you very much. And I'll get in the back. I won't only ask people in the front. So we'll.
Hi, my name is Lindsay. I'm from UC Davis, and given the tense climate across campuses, do you think that there needs to be more of a push for transparency from the administration, and maybe saying we don't know what the solution is, but we're working on it, or even acknowledging events? You know, when we had white nationalists come to our cross-cultural center, there was silence, and so students kind of don't know quite where to turn. And I was just wondering if you thought that some kind of acknowledgement of events that happen, or even acknowledgement that you're working on something might be better than just silence because there's not a direct answer.
Yes. I do think administrators and perhaps faculty should speak out. And I also think we should acknowledge when we don't have a nice, neat solution. And I think that, there are questions about, when administrators should speak out and in what forum. Some may have thought they spoke out, but they just weren't heard. Yeah, I think that's part of our obligation.
Any comments?
I would just say, I agree with President Napolitano. These are difficult issues for universities and colleges to deal with, especially when, as President Napolitano alluded earlier, you have speakers who appear to be designed to do nothing other than show up and insult people and attack people and degrade people. The First Amendment may, in certain circumstances, protect that. And even when people do that, even if it is protected by the First Amendment, it doesn't make it right. And it makes it sad and tragic that some people may abuse the freedom of speech that we enjoy in this country in such a way. But I do agree with President Napolitano, and I'm not a university administrator or president like President Napolitano, but I would just ask all the students to bear with the administrations here, because I think these are very difficult issues for President Napolitano and her peers and colleagues to deal with at times, and difficult for students too, and so I don't mean to minimize that at all.
Thank you. I think we had a question in the back. I'll try to get the...
Hi, my name's Connor Strobel. I'm a graduate student at the mighty UC Irvine, who'll be winning their basketball game tomorrow at 2 p.m. Eastern. Zot, zot. My question to Assistant Attorney Dreiband is, periodically, each campus, in conjunction with students, administrators, come together and revise their student codes of conduct, their SCSH policies, and other things, in many ways to be in compliance with changing federal statutes and regulatory requirements. And my question comes out of thinking when you're listing some of the exemptions to the First Amendment, and you had mentioned that one of the exceptions is either severe and pervasive speech. And historically, with kind of our governing documents and most employment discrimination, civil rights things, it's either been severe or pervasive. So I'm wondering if you could explain kind of with that recent sort of change historically, why you think that's the case.
Yeah, I may have misspoke. It's an excellent question. No, but you're right. That is the articulation of the standard about harassing conduct under most civil rights statutes. So you're correct. It's severe or pervasive. So that's correct. And I wish the anteaters well at UC Irvine. So.
Good call.
Okay, I think we got something in the back, and then I'll get in the front. So the gentleman in the back, and then the woman in the front here.
Hi, my name is Carlin Romano. I'm one of the fellows of the center this year. I have a question about the statements of interest, and this may come out of my own legal illiteracy, but I'm wondering first whether the Supreme Court or any of the circuit courts have ruled on whether the Justice Department filing statements of interest is itself unconstitutional in free speech cases. This is my surface idea. If, as you say, the Justice Department files these statements of interest after a record has been developed, after discovery and so on, they're adversarial parties, and I'm assuming the Justice Department is signaling its interest in which side should win. That would seem a violation of viewpoint neutrality on the part of the Justice Department. Now, maybe statements of interest say, okay, 7 arguments on this side, 7 arguments on that side, you, court, decide. But if you're signaling which side you think should win, isn't that a violation of viewpoint neutrality and unconstitutional?
The answer is no, it's not. What we do in statements of interest is that we explain to the court the First Amendment standards. In a First Amendment case, we file statements of interest under other laws and statutes as well. And there is an explicit statute that authorizes the Justice Department to file what are these statements of interest. What we do is we analyze the record as best we have it, and we make a judgment, number one, whether the government has an interest in the case of free speech cases, whether or not we think there is a legitimate issue and a legitimate interest the government has in defending the protections contained in the First Amendment. And then from there, we simply explain to the court in our statements of interest, given the record that the court has before it and that we have before us, that the legal standards that govern and whether in our judgment the legal standards as applied to the facts of the case or the allegations, the record, etc., whether or not in a particular matter there was a First Amendment violation. In some cases, we simply explain the standards and don't take a position on who should win the case, for example. But if there are allegations and the evidence supports them, we will explain to the court our judgment that under the standards that are embodied in the First Amendment, number one, the standards that govern, and number two, how those standards apply to the facts of the case. And that is not in any way a violation of the First Amendment to explain how the First Amendment should work to a court.
Thank you very much. And I think we had a question right up. Yeah. And then I'll go get a question here. We have time for maybe a couple more questions, and then we'll wrap it up.
Hi, so my name is Kimberly, and I'm from UCSD. First of all, I appreciate what you said about the university's obligation to both protect the freedom of speech and students who feel like they're particular targets. In the reading we had, it was, I don't know what it's called anymore, but it's called a fact sheet, unlike universities and like higher education and stuff. And it explicitly says that there's no no legal no definition of what hate speech is. So I guess the difficulty with this conversation is that you can't tangibly measure how much someone is hurting or offended by hate speech. So I guess my question is, where do you draw the line between hate speech and the freedom of speech?
Well, I actually think the First Amendment applies to hate speech, and that's how broad it is. And speech is speech, and it has certain very narrow exceptions, but the exceptions need to be narrow because otherwise you put the government or some other entity in charge of deciding, well, is that hate speech or not hate speech? And you don't want that kind of censorship. So what you need to be able to do is to counter it, to support the targets, as Eric said, to bring in alternative speakers, have other options for students to follow or adopt. But the breadth of the First Amendment is itself breathtaking. And I think one of the things we need to do in colleges and universities is really educate our students about what that means.
And can I add one small point? Because you raise an excellent point, but I think I agree with President Napolitano's comments, first of all. But I think it's important when we start thinking about the breadth of the First Amendment and maybe concerns that you may have that maybe the protections are broader than we think appropriate with hate speech. But I think it's important to step back and think, well, what is the purpose of the free speech protections of the First Amendment? The purpose of those protections is to protect all of us from the government. Now, it may be funny as a member of the government currently for me to say that. That is, the free speech protections are to protect all of you from me. But that's the purpose of it. It's not to protect Americans from hurtful speech, but rather to protect us from the government stepping in and censoring what any of us might say. And what might be hate speech to one of us might not be to the next of us. And the concern is that the government, as President Napolitano said, could step in and start making those kinds of judgments and then taking away our freedom of speech, which is what we don't want.
I'll just take one more question from maybe in the back over here. And get a mic back here.
My name is Janine, and I'm from UC Davis. I just wanted to ask, considering America's relatively contested historical legacy regarding free speech and censorship, especially regarding the media in the early 19th century, and considering cases where you could prosecute someone for calling someone a quote-unquote damned fascist under disturbing the peace, do you think it's likely that the way that we litigate free speech in the First Amendment will change in the next century?
Just for context, this is from the Chaplinsky ruling in the 1940s, and that was a statute criminalizing speech that was offensive was upheld, and the person had called this person you said what they called them. So I mean, it's hard to imagine that would be criminalized today, but it was criminalized in the 1940s. So.
I think it is certain that First Amendment litigation will continue. I agree with the question, or the premise of the question, in the sense that we as Americans have had a mixed history with First Amendment protections. This goes back to when John Adams was the president, when he signed the Alien and Sedition Acts that trampled all over what today we would regard as clear protections embodied in the First Amendment, freedom of speech protections. We've had these incidents over our history where First Amendment violations have occurred. They will continue to occur at times, tragically, but they will occur, and we will see ongoing fights in the federal courts with these things, both with respect to college and university free speech issues and otherwise. I think we will see it especially in the realm of social media, which is obviously relatively new in terms of how the First Amendment will apply to speech through social media and the internet and things like that, but there will always be an ongoing, I think, struggles in our country about the scope of First Amendment protections, and there will be changes as technology and speech takes different forms.
Okay, well, with that, I'm going to thank President Napolitano and AAG Dreiband.
Thank you. It's a pleasure.
It was fun. Yeah.
And all of you, and particularly the students, and it's absolutely terrific for all the students who are here that you've taken time out of your very busy schedules to engage in this very important
and
topic.
I'm gonna have the final word. You guys can exit. Thank you to the panelists. We have come to the end of what I think, and I realize I am not objective, a tremendous day. And now is the time to recognize people, because days like this don't happen without a dedicated team. So this center was conceived of and is led by three incredible scholars and people, President Napolitano, Chancellor Gilman, and Dean Chemerinsky, and I'm grateful for their support and insight. The center has an outstanding national advisory board, many of whom contributed during today's panels, and I want to thank them for their commitment to the center's success. 10 members of our newly formed academic advisory board are also here today, and I so look forward to working with them to grow the center together. Again, I want to recognize our inaugural class of fellows whose important work showcases that speech really does matter. I also want to recognize Chris Harrington, the Associate Vice President of Federal Government Relations for the University of California, and his terrific team for all of their support and assistance. This conference would not have happened without the talented Glen Echo Group, who are responsible for everything that looks beautiful about this conference. Special thanks to Courtney Cowper, Katie Barr, and Ren Dillingham. And last, but certainly not least, I want to recognize Brenda Pitcher. Where's Brenda? She's right there. Brenda is our center's executive assistant, and it is because of her unparalleled attention to detail and unrelenting optimism that we were able to have a successful event. So I think I like to end on a high note. I think there are a lot of challenges and there is a lot of work to be done, but I think there is much to celebrate. The fact that we could spend an afternoon thinking about and disagreeing about speech in America, I think is something worth celebrating. And I hope that you'll join me for drinks and food and further discussion. Thank you so much.